costs and fair, using the word fair. So when David brings that up, I'll let him walk through what he has brought to us today, but it's also on our committee page. If you've got it up yourself, you can make sure that it's got today's date on it. Draft 4.1. You're going to see yellow highlight and you're going to see blue highlight.
So fun.
I got the blue.
Do you want to put it up on the screen?
Yes.
All right. Thank you for allowing me to co-host with you.
You got it.
So good morning, David Hall, Legislative Council. I think we're back to H81. And I am pulling up, as the chair indicated, a draft 4.1 amendment. And this is multimodal coloring. And the reason for the multiple colors is this. So we have the underlying bill. Then I came back to you with a 1.1, and I don't remember if we looked at 2.1 together or not, to be honest with you. So basically 4.1 is making additional changes to 2.1. So the yellow that you see are the 2.1 changes, and then the blue are the 4.1 changes, okay? For the first couple of pieces in the definition section, and then things get really wild later on at the bottom of 8. I wasn't sure if this was a bit you wanted to discuss, this concept of essentially the same terms versus fair and reasonable terms. So if you do, we can. If you don't, we don't have to. But let me start with the changes up here at the top. So we are in the definitions, remember, talking about the scope of the universe. And one possible approach, so let me take one step back. Remember that, the duty applies to a manufacturer, right? And the duty is provide parts, tools, documentation. All right, on what basis? We're going to say some basis, fair and reasonable terms, link it to what you make available to authorized repair providers, depending on who they are, where they are, lots of moving parts there. But essentially the duty is you manufacture, supply this stuff. And the way 81 came to you, the way it still works in this version, in not the option B, but in what I guess we could say is option A, what we have before us and have had all along, is this concept of fair and reasonable terms. We've talked together about how fair and reasonable terms means different things depending on what we're talking about. So for parts, it means the costs are fair to both of the parties, considering, the agreed upon conditions, the promised quality, the timeliness of delivery. The term provisions are basically the same for each of parts and for tools. You're not imposing some sort of additional burden or condition or unnecessary burden that's supposed to act as an impediment or some duty or restriction on the use that you wouldn't otherwise apply to an authorized repair provider, right? So the difference, though, between parts and tools, specifically with respect to cost, is that whereas costs for parts have to be fair to both parties, the underlying bill says that costs for tools let's look at it, forgetting the blue for a moment. For tools, the cost for the tool does not exceed the lowest actual cost for which the original equipment manufacturer offers the tool to an authorized repair provider, including any discount, rebate, or other financial incentive offered to an authorized repair provider. So you'll see that the blue language modifies this slightly in the first bit to say it's going to be subject to this additional provision in 2. And then the additional provision in 2 says an original equipment manufacturer may impose an additional charge if and only to the extent to which it incurs reasonable additional costs to make a tool available for sale to an independent repair provider or owner.
You want to, yeah, let's jump in.
Yeah, so the implication of this is that suggesting that the manufacturer is selling those parts at wholesale price to the client? The client being the individual tractor owner as opposed to the authorized dealership? I can restate that.
I'm not sure I understand the question.
So
We're in tools here. They'll just point out, not parts.
oh, yes. So, but either or, tools or parts. The impression I get from this is that the manufacturer is putting the sale price of the tool at the same price made available to the authorized service provider. So that is essentially a wholesale price.
I don't know what the price is. I mean, you call it wholesale, and to the extent that it's not retail, sure, it goes from manufacturer to dealer.
Right.
If that's what you mean by wholesale, then yes.
That is what I mean.
Okay. So yes,
Okay.
what's relevant about that, though, is the potential differential in cost incurred to the manufacturer as between what it actually costs them to supply the tool to the authorized repair provider versus what it might cost to supply to an independent or an owner. This issue is exacerbated by the construct of the bill as it currently stands, in that the authorized repair provider, for purposes of this version of this bill, it doesn't matter where they are. And so first, if it's a separate entity. Second, it could be the manufacturer itself, right? Because this bill provides for and does contemplate the situation where the OEM doesn't have this franchisor franchisee relationship for its system. Rather, it is the authorized repair provider, and it provides that service itself. So this manifests in a couple of different ways. I mean, one problem that isn't addressed in this bill is that, we're saying you have to do business here. But if we're talking about the burden, the relative benefits and burdens of, economic regulation, one way to mitigate sort of an uneven burden is to at least say to a manufacturer, you have the opportunity to at least recoup your cost. If it legitimately costs you more money to send a tool to Vermont, let's say you're in Indiana,
Yeah.
The other problem that this seeks to address somewhat is that, we've talked a little bit about the extraterritoriality concerns and how they can be impacted by cross-jurisdictional price setting. And the one problem that it sets up, if you have no ability to adjust your price in Vermont, is that your price is now stuck in another jurisdiction. And you have two options at that point. You can either increase the price in the other jurisdiction so that your lowest price in Indiana is enough to offset your cost in Vermont, in which case we're now forcing you to change your business activity in Indiana, or you have to just eat the money in Vermont because you still want to be able to sell an Indiana tool at an Indiana price, but that will be 20% less than the Vermont cost. So that's your impossible choice. Lose money in Vermont or lose money in Indiana, right? And then on top of that, the way the bill is written, you don't have the opportunity not to participate in our market. So to try to mitigate some of those risks is to give the opportunity to say, if there is a legitimate reason it costs you more to sell it in Vermont, then you can recoup the difference of that cost. And it has to be a reasonable additional cost. You can't just make it up.
So is that then covered by this blue section on the next page?
Well, that part of it is.
Okay.
The ability to adjust your price is covered by the blue section. And this is, again, is specific to tools because you've already said for parts, it's got to be a fair price for the part for both parties considering blah, blah, blah.
Henry.
Is the legitimate additional cost, could it be argued that the additional cost could be needed because they're no longer gonna make money using that tool? You get where I'm saying? Like,
I do. You're talking about the opportunity cost of. I mean, that's not what this envisions. I mean, this is really, and if we needed to change the words, we can. But again, it incurs a reasonable additional cost to make that tool available for sale to an independent provider or owner.
John.
But what happens when the OEM makes a tool that can only be used by essentially, say, we'll use John Deere again, John Deere mechanics who have gone to school specifically to use that tool? So is the OEM still required to send a tool to potentially an untrained mechanic or farmer?
I mean, yes, this bill as it written would require that.
Okay, other questions or clarification on this section?
So if you want to look at the option B construct, it would be, I think now would be the time to do that and then come back to trade secrets, but
Yeah.
it's up to you.
No, let's definitely
Okay.
skip over trade secrets for the moment.
All right. So as I was working through thinking about the construct on what's fair and reasonable, and also taking a sort of a bigger step back on the purpose of this bill. Again, if we are saying, what we want is to place a burden on a manufacturer to comply with this duty, that's the entity that we are regulating. The question of on what terms is where authorized repair providers come in, right? And so there are ways to do that. One way is to say fair and reasonable and then define what fair and reasonable means. A slight alternative that occurred to me is this, what I'm thinking of as a substantially the same terms approach. And it's really a hybrid where the base case is what we're saying is your duty to comply is the duty to make this stuff, parts, tools, documentation available, basically on the same basis that you make it available to your authorized providers. Now, again, this bill as it written says authorized repair providers, period. Doesn't matter where they are. You could narrow that to ones that just service specifically the Vermont market. You could narrow it further to say just repair providers in this state. Obviously, there are trade-offs. And so right now, this is sort of the broadest scope of what is the basis of your duty. It is the duty, or it is the terms and the costs at which you provide it to authorize, wherever they may be. We want you to provide them to independents and owners in the state. So you'll see the way that my 4053 here works, it sort of mashes together It takes fair and reasonable terms out of the definitions. It mashes the duty and the terms together in one section. So it says, here's your duty and here's the basis of the duty. So the duty is in A. An OEM shall offer for sale or otherwise make available to an independent repair provider, it says consumer, it should say owner, the parts, tools, and documentation that the OEM offers or for sale or otherwise makes available to an authorized repair provider. A, subject to subsection B of this section on substantially the same terms, and B, subject to subsection C of the section for substantially the same cost. Two is a vestige it carries forward. An OEM may make parts, tools, documentation available either directly or through an authorized repair provider. The bracketed language on lines 13 and 14, if permitted by an agreement between the manufacturer and the dealer or provider, serves a couple of different functions. One is to make it clear. I know there's been concern expressed in this committee about the extent to which these duties may flow to the authorized providers. And this would sort of address that, but more than that, this is really a contracts clause sort of safeguard that says we're not going to force you to violate your franchise or license agreement by now allowing the manufacturer to make you give up parts, tools, and documentation. We'll say, if your private agreement, which you have already reached or are negotiating, allows it, we can pull you into this process. Otherwise, the duty remains on us as manufacturers. That's not something you have to do for this bill, something for you to consider. So the terms, they are largely the same as in the underlying bill. They're just all in one place. So this would apply to parts and tools and documentation. One subsection to deal with all of those and the terms. So under the terms, the governing the sale of provision of parts, tools, documentation, OEM shall not impose on an independent repair provider or consumer, one, you've seen these, the substantial obligation to use or the restriction to use those for services, including that you become an authorized repair provider, that you register it or do some other step to make sure it works. Two, an additional cost or burden that is not reasonably necessary is designed to be an impediment on the independent repair provider owner. Or three, an additional burden or material change that adversely affects the timeliness or method of delivering parts, tools, or documentation. So that really pulls together all of the limitations on changing the terms into one subsection, and it's applicable to parts, tools, and documentation. It's a similar construct here in C. I'm sorry that I should have this sideways so you all can see it better on the screen. So for C, this addresses now costs and the limitations. So subject to subdivision 2, OEM shall offer for sale or otherwise make available parts, tools, and documentation to the independent or the owner at a cost that is fair to both parties, considering the agreed upon conditions, promised quality, timeliness, includes any discount, rebate, or other financial incentive offered to an authorized provider. So that's sort of the baseline, but then we're going to be subject to 2 here. An OEM may impose that additional charge for parts, tools, or documentation if and only to the extent which the manufacturer incurs additional cost to make them available for sale or otherwise available to the independent. Or you can also change the terms of the cost if the parties agree to a material change in the cost or terms concerning the provision of parts, tools, or documentation and agree to an additional charge that is reasonably related to the additional costs arising from the material change. So that protection we talked about above that's built into tools would sort of apply across the board here, right? And say baseline case, same terms, substantially the same terms as you are offering to your authorized, still has to be fair, still needs to include the discounts, the rebates that your authorized would benefit from, but you can, and this is again, it's for parts, tools, or documentation, because I don't know what I don't know about the facts of what they do or don't impose charge for. I'm sure it's different across all kinds of manufacturers, whether it's a diagram, schematic, a technical manual, a part, a tool, whatever. You should be able to reasonably adjust the price if there's a legitimate basis for selling it at a higher cost in Vermont. And the party should be able to negotiate these terms under 2B if that's what they choose to do.
Representative Graham?
So an owner or a repair person have to go straight to the manufacturer to get parts. Can't go to the dealer and say, you gotta sell me the part the same price you paid for.
The way it's written now, you cannot just show up at an authorized repair provider and say, you have a duty to give me parts, tools, or documentation. That duty doesn't flow to the provider. That duty flows to the manufacturer. The way the underlying law is built, it says that the manufacturer can meet that duty either by sending it directly or it could do it through a provider. The issue there is that this bill is not telling the provider they have to follow and do what the manufacturer says. That's going to be governed by their whatever agreement they have, right? Their franchise or license agreement, whatever it is that's governing their relationship. And if that agreement doesn't give the manufacturer the legal authority to force them to sell it to other people, which in all likelihood it doesn't, then the authorized repair provider could refuse. And the manufacturer can't point to this law and say, no, this law says you have to provide it. The repair provider say, no, this law says you have to provide it. And you can send it through me if I agree to it, or if our agreement has made provision for that. But the duty is to the manufacturer, not to the franchisee.
So follow up, I mean, dealership investment in infrastructure, inventory. And if a person can go straight to the manufacturer and get these tools and get these parts, same price dealer can acquire them, how is the dealer gonna survive?
Well, that's a fair policy question, and that's not one that I can answer. What I can say is from a legal perspective, to the extent those franchisees, those authorized providers are in state, that's just tough noodles for them if this is a law that you pass. If they're out of state, it would contribute to the balancing considerations of where the respective burdens lie, out of state versus in-state interests that have to be balanced out. So
You know, a lot of the manufacturers are out of the country.
that's another, I'd say 99.5% of them probably. And so that's another, coin in the weights of justice, right? I mean, that's a balancing that I can't give you a definitive answer on how that equals out, but definitely the burden is more out of state in that respect.
So could this it play into fair trade agreements between the United States and other countries?
I don't think so. The reason being that those require equal treatment generally among domestic and foreign entities. And so it's usually like, buy American provisions that are problematic, not so much the domestic treatment of respective actors among states. I mean, I have to think about it more with respect to maybe a Canadian company. I mean, that brings in a whole different set of agreements, and we get to the issues of whether anybody could actually enforce any of this WTO against us. That's a whole rabbit hole that I can't off the cuff give you all the answers to.
Representative, or go ahead.
A lot of maple equipment is made in Canada,
Sure. Yep.
and that's our agriculture.
Yeah. Yeah. And so, there's the questions that come up there are the same as for other states, we're trying to surely do something for our consumers, but for their benefit, but at what external cost?
Representative O'Brien?
Maybe this first.
David?
How deep are these obligations in terms of the manufacturer providing this equipment? Meaning, like, say 20 years has passed and they no longer manufacture this part. Are they at that point no longer obliged to provide parts and tools?
They are under this law as it's currently written, they are obliged to provide those parts, tools, and documentation to the same extent they provide them to authorized repair providers.
So if they no longer produce them, then they're no longer obliged.
That would be my interpretation.
Very good.
Yes.
Now Representative O'Brien.
So, we should probably have an authorized dealership come in and explain that relationship between the OEM and their business. But I can imagine a situation where the authorized dealer essentially contractually has access to tools and documentation, but they never actually buy them. It's almost like a lease, or, as long as you're part of our family, you get access to these tools. So how would that work with farmers and independents?
Well, so again, I think it depends on what construct you take. I mean, if it's sort of the so-called option A, what we currently have in the underlying bill, it's basically negotiated for parts. Tools are least costs, which if that means free, then that means free without any opportunity for adjustment. And the same for documentation. It has to be free unless, and you've added in your draft 1.1 provision for being able to impose a charge if you would normally impose a charge on an authorized. Option B would allow for adjustment in any of those circumstances based on, the reasonable additional costs for making it available to Vermont consumers, businesses. Consumers includes businesses, but I say both here.
So if the OEM says you get to use these parts, not parts, but tools and documentation as part of our business family. But even then, at your dealership, only the people who have been trained to use them really have access to them. How does that work with farmers and independents?
I don't think I don't think it changes the answer, and I think it raises one of the burdens on a manufacturer potentially is reputational risk if something goes wrong, or exposure to civil litigation if somebody gets injured. So they give you the tools and the stuff, you try to make a repair, it doesn't work out, your tractor, I don't know what, catches on fire. Maybe you get hurt, maybe you don't, I don't know. But people will say, look at this, like that company's stuff isn't safe because when you try to fix it, it blows up. This is obviously a hypothetical, but the answer is that's a potential risk or burden to a manufacturer that we're not accounting for when we say your duty is to give them the tools and the information to do the repair. We're not doing much else, right? I mean, we're not saying you have to go have a trained person to be able to access this material. We're just saying you get the material. You have to buy it, if you're, the other people have to buy it. But you do have access to it.
Does the language, either current or proposed here under terms, address that at all? So the hypothetical requirement that there be training to use the tool.
Well, right now, dealers send their mechanics out to some place to be trained on tools. I don't think we're gonna make the manufacturer require the customer. I mean, the dealership, you pay for that. It's not the manufacturers that pay for the mechanics to go to school.
So my answer is that the language doesn't explicitly respond to that one way or the other. But it does say, under the terms, well, I'll go back up to the top to where it's currently in the definitions. It says you can't impose any substantial obligation to use or any restriction on the use of the part to conduct repair. You can't make them become an authorized repair provider. You can't make them register the part or pair it with the part before it will work. And you can't impose any additional cost or burden that is not reasonably necessary or is designed to be an impediment on the owner of the repair or the repair provider. So that's squishy in this context. I mean, could they say our term of you getting this tool is that you learn how to use it from us? Maybe that's a reasonable requirement, or maybe that's a burden and an impediment. I don't know the answer.
Good answer. Representative Lipsky.
David, in recent testimony we've gotten, the issue of upgrades have come up. You can have some software and there seem to be continual upgrades that may change codes or functions. Does it happen 30 times a year, 3 times a year? I don't know. But if there is an upgrade from the manufacturer, each time they make an upgrade, does that need to be, do they need, is that an additional request with a cost?
So
I'm not trying to complicate it, but that's
No.
a real issue.
Sure. I think it's a good question. I would say that the bill intends that any updates are part of the software that you'd have to make available. Does that happen automatically? Do they push those out to every person that has requested it in the past? I doubt it. I would think it's a separate request. And if there's a separate charge or a separate basis for a charge, then they can impose that. But it's at least definitely, I would say, contemplated and intended by the language that you're not stuck with the old version of 1.0 software. You're supposed to be able to access updates as part of what's available to you.
So I saw you scrolling down, and just before we leave, before we spend a moment, and there won't be much more than a moment, talking about the trade secret language, David, could you summarize just option A versus option 1 versus 2, A versus B here?
Sure.
In a sentence or two?
Yeah. A is what you basically have now, which says, if we're talking about what is the scope of the duty, then that the scope is provided it being parts or tools or documentation on fair and reasonable terms as we define it. And further modified by that additional piece on the cost of a tool that says you should be allowed to, recoup the additional cost so that you're not at least losing money. That's A. B is essentially for all parts, all tools, all documentation. Your guiding lodestar is substantially the same terms as what you make it available to an authorized repair provider, provided that it's fair to everybody, that you're not imposing all the unreasonable burdens, and that if you need to adjust the cost for any of it, either by agreement or to recoup that additional reasonable charge for selling in our state, then you can do that. Okay. So it really, I'd say B standardizes the duty across parts, tools, and documentation in a way that's a little more, I don't say nuanced, but it's just different among those three when we say what does fair and reasonable mean. Okay.
Okay, good. So I will flag that we now have at least a couple of pretty concrete approaches to consider in which, how we address that piece of it.
Mm-hmm.
So we'll leave that just while we still have you for a couple minutes. And I don't know how long we could ask you to stay.
I can be here for as long as you need. I'm free.
We have to be elsewhere at noon, and our only break is whatever we leave ourselves. So I'm gonna suggest that we just really stick to, if we can cover briefly in 5 minutes, what else you want to say about trade secrets, then we'll come back to it when we're able to spend more time.
All right, 5 minutes. Okay. Well, it's not a problem of explaining the change here. So you'll see the way that the underlying proposal, it just incorporates the definition of trade secret by reference from Title IX. Again, this is sort of the model framing, defining of trade secret. It's consistent across, I want to say it's like 7 states. It's a model law that's based on the restatement, sort of underlines what do we mean when we say trade secret. And again, for purposes of our law, we say, first of all, we prohibit the sort of fraudulent or some sort of bad way of accessing a trade secret. You're not permitted to do it, but you do it anyway. That's a problem. You got enforcement, blah, blah, blah. And we say, if a court's going to be looking at this, they have to keep it secret to the extent they're considering whether or not it even is a trade secret, right? So we're trying to keep the trade secret safe and secret. So 11A is that definition. It means information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure or use. And 2, is the subject of efforts that are reasonable under the circumstances to maintain its secrecy.
So that's just the language the existing language that we were referring to, and now we're putting it right in here.
Right. That's step 1.
Yeah.
Step 2, though, is to say, for purposes of this chapter, in this state, a trade secret does not include a part, tool, or documentation that is necessary to perform diagnosis, maintenance, or repair of, agricultural or forestry equipment, and an original equipment manufacturer sells or otherwise makes available to an authorized repair provider in the ordinary course of business to perform diagnosis, maintenance, or repair of that equipment.
Right. That's brilliant.
So here's the reason this is here. I got 2 minutes. A trade secret is intellectual property. There is a Fifth Amendment, and I haven't looked at it, but we have a provision in our own Constitution that also says, you can't take private property for public purpose without just compensation. Standard takings, eminent domain analysis. I think there's no question here that that's true about trade secrets. Factually, I have no idea the extent to which, all the stuff that we might be forcing them to give away may or may not be considered a trade secret. That is an argument that the business is going to make. What are the implications of that? If it is a trade secret, there is an intellectual property right. And if that is taken by the force of law, there has to be just compensation. That just compensation can come from the fact that, the independent or the owner actually has to buy the thing from the other person. So that's sort of covered there. Now that there might be a gap if what they pay isn't what it's actually worth, or for some reason that compensation is not just in the manufacturer's eyes, in which case they could sue the state and say, you've taken from us a whole lot more than just $49.95 for the part or for the software code that is proprietary and we didn't want the world to have. And now the whole world has it because we sold it to one Vermonter. They posted it on the internet. Now the whole world knows what our security codes are, right? So one way to insulate a claim for a taking of a trade secret. A trade secret is based on a property right, and a property right is based in state law. And state law sets essentially the expectation of what the secrecy provision will be. Part of having value in intellectual property, in any kind of property, is that you have reasonable investment-backed expectations and some attempt to maintain the secrecy. What the Monsanto case teaches us, and there's a lot of nuance in that case, I'm not going to try to go into it right now, but essentially, if there is notice, awareness that for a regulatory purpose, your trade secret is not going to be kept secret, then you don't have a reasonable investment-backed expectation that it will be. So the attempt here is to say, don't expect that if you are selling equipment in our state, that something you might consider to be a trade secret won't necessarily be, governed by the operation of our law. The definitional change is only one piece of that protection. The other pieces that I would strongly recommend, but are substantially change the scope of this bill, is that you only apply this bill to stuff that's made after a certain date and that it's delayed in its effectiveness so that there is adequate notice to the world that you are no longer going to have this expectation of privacy.
Okay. Well, you kept it pretty close there to 5 minutes. But you're right, obviously a bigger subject. But no, I think what you accomplished, what I hoped to accomplish was just setting out these two, getting into a little bit more of these two things that we've, chatted around a little bit. So when we come back, and I'm not sure when that will be, we'll check with your schedule. We'll see what we have time for. We'll pick this up where we left off.
Sure. Sounds good.
Thank you, Dan.
Thank you.
Yeah, glad to be here. Enjoy your break. I hope you get one. And your lunch.
A short one.
Tiny one.
Yeah. So, right, everyone, I don't know what other committees are